Of abetment, criminal conspiracy and attempt. Of abetment. 45. Abetment of a thing. A person abets the doing of a thing, who a. instigates any person to do that thing, or b. engages with one or more other person or persons in any conspiracy for the doing of that thing, if an act or illegal omission takes place in pursuance of that conspiracy, and in order to the doing of that thing, or c. intentionally aids, by any act or illegal omission, the doing of that thing. Explanation 1. A person who, by willful misrepresentation, or by willful concealment of a material fact which he is bound to disclose, voluntarily causes or procures, or attempts to cause or procure, a thing to be done, is said to instigate the doing of that thing. Illustration. A public officer is authorized by a warrant from a court to apprehend ZB. Knowing that fact and also that C is not Z, willfully represents to A that C is Z, and thereby intentionally causes A to apprehend C. Here Babbitt's by instigation. The apprehension of C. Explanation 2. Whoever, either prior to or at the time of the commission of an act, does anything in order to facilitate the commission of that act, and thereby facilitates the commission thereof, is said to aid the doing of that act. 46. Abettor. A person abets an offence, who abets either the commission of an offence, or the commission of an act which would be an offence, if committed by a person capable by law of committing an offence with the same intention or knowledge as that of the abettor. Explanation 1. The abetment of the illegal omission of an act may amount to an offence although the abettor may not himself be bound to do that act. Explanation 2. To constitute the offence of abetment, it is not necessary that the act abetted should be committed, or that the effect requisite to constitute the offence should be caused. Illustrations. A instigates B to murder C. B refuses to do so. A is guilty of abetting B to commit murder. B. A instigates B to murder D. B in pursuance of the instigation stabs D. D. Recovers from the wound. A is guilty of instigating B to commit murder. Explanation 3. It is not necessary that the person abetted should be capable by law of committing an offence, or that he should have the same guilty intention or knowledge as that of the abettor, or any guilty intention or knowledge. Illustrations. A. With a guilty intention, abets a child or a person of unsound mind to commit an act which would be an offence, if committed by a person capable by law of committing an offence, and having the same intention as A. Here A, whether the act be committed or not, is guilty of abetting an offence. B. A, with the intention of murdering Z, instigates B, a child under 7 years of age, to do an act which causes Z's death. B, in consequence of the abetment, does the act in the absence of A and thereby causes Z's death. Here, though B was not capable by law of committing an offence, A is liable to be punished in the same manner as if B had been capable by law of committing an offense, and had committed murder, and he is therefore subject to the punishment of death. C. A instigates B to set fire to a dwelling house. B. In consequence of his unsoundness of mind, being incapable of knowing the nature of the act, or that he is doing what is wrong or contrary to law, sets fire to the house in consequence of his instigation. B has committed no offense, but is guilty of abetting the offense of setting fire to a dwelling house, and is liable to the punishment provided for that offense. D. A. Intending to cause a theft to be committed, instigates B to take property belonging to Z out of Z's possession. A induces B to believe that the property belongs to A. B takes the property out of Z's possession, in good faith, believing it to be his property. B, acting under this misconception, does not take dishonestly, and therefore does not commit theft, but is guilty of abetting theft, and is liable to the same punishment as if B had committed theft. Explanation 4. The abetment of an offense being an offense, the abetment of such an abetment is also an offense. Illustration. A instigates B to instigate C to murder Z. B accordingly instigates C to murder Z, and C commits that offense in consequence of B's instigation. B is liable to be punished for his offense with the punishment for murder, and, as A instigated B to commit the offense, A is also liable to the same punishment. Explanation 5. It is not necessary to the commission of the offense of abetment by conspiracy that the abettor should concert the offense with the person who commits it. It is sufficient if he engages in the conspiracy in pursuance of which the offense is committed. Illustration. A concerts with B a plan for poisoning Z. It is agreed that A shall administer the poison. B then explains the plan to C, mentioning that a third person is to administer the poison, but without mentioning his name. C agrees to procure the poison, and procures and delivers it to B for the purpose of its being used in the manner explained. A administers the poison, Z dies in consequence. Here, though A and C have not conspired together, yet C has been engaged in the conspiracy in pursuance of which Z has been murdered. C has therefore committed the offense defined in this section and is liable to the punishment for murder. 47. Abetment in India of offences outside India. A person abets an offence within the meaning of this Sanhita who, in India, abets the commission of any act without and beyond India which would constitute an offence if committed in India. Illustration. A, in India, instigates B, a foreigner in country X, to commit a murder in that country. A is guilty of abetting murder. 48. Abetment outside India for offence in India. A person abets an offence within the meaning of this Sanhita who, without and beyond India, abets the commission of any act in India which would constitute an offence if committed in India. Illustration. A, in country X, instigates B, to commit a murder in India, A is guilty of abetting murder. 49. Punishment of abetment if act abetted is committed in consequence and where no express provision is made for its punishment. Whoever abets an offence shall, if the act abetted is committed in consequence of the abetment, and no express provision is made by this Sanhita for the punishment of such abetment, be punished with the punishment provided for the offence. Explanation. An act or offence is said to be committed in consequence of abetment, when it is committed in consequence of the instigation, or in pursuance of the conspiracy, or with the aid which constitutes the abetment. Illustrations. A instigates B to give false evidence. B, in consequence of the instigation, commits that offence. A is guilty of abetting that offence, and is liable to the same punishment as B. B, A and B conspire to poison Z. A, in pursuance of the conspiracy, procures the poison and delivers it to B in order that he may administer it to Z. B, in pursuance of the conspiracy, administers the poison to Z in his absence and thereby causes Z's death. Here B is guilty of murder. A is guilty of abetting that offence by conspiracy, and is liable to the punishment for murder. 50. Punishment of abetment if person abetted does act with different intention from that of abettor. Whoever abets the commission of an offence shall, if the person abetted does the act with a different intention or knowledge from that of the abettor, be punished with the punishment provided for the offence which would have been committed if the act had been done with the intention or knowledge of the abettor and with no other. 51. Liability of abettor when one act abetted and different act done. When an act is abetted and a different act is done, the abettor is liable for the act done, in the same manner and to the same extent as if he had directly abetted it, provided that the act done was a probable consequence of the abetment, and was committed under the influence of the instigation, or with the aid or in pursuance of the conspiracy which constituted the abetment. Illustrations. A instigates a child to put poison into the food of Z, and gives him poison. For that purpose, the child, in consequence of the instigation, by mistake puts the poison into the food of Y, which is by the side of that of Z here, if the child was acting under the influence of his instigation, and the act done was under the circumstances a probable consequence of the abetment, A is liable in the same manner and to the same extent as if he had instigated the child to put the poison into the food of Y. B. A instigates B to burn Z's house. B sets fire to the house and at the same time commits theft of property there. A, though guilty of abetting the burning of the house, is not guilty of abetting the theft, for the theft was a distinct act, and not a probable consequence of the burning. C. A instigates B and C to break into an inhabited house at midnight for the purpose of robbery, and provides them with arms for that purpose. B and C break into the house, and being resisted by Z, one of the inmates, murder Z. Here, if that murder was the probable consequence of the abetment, A is liable to the punishment provided for murder. 52. Abettor when liable to cumulative punishment for act abetted and for act done. If the act for which the abettor is liable under Section 51 is committed in addition to the act abetted, and constitute a distinct offense, the abettor is liable to punishment for each of the offences. Illustration. A instigates B to resist by force a distress made by a public servant. B, in consequence, resists that distress. In offering the resistance, B voluntarily causes grievous hurt to the officer executing the distress. As B has committed both the offense of resisting the distress and the offense of voluntarily causing grievous hurt, B is liable to punishment for both these offenses, and, if it knew that B was likely voluntarily to cause grievous hurt in resisting the distress, A will also be liable to punishment for each of the offenses. 53. Liability of abettor for an effect caused by act abetted different from that intended by abettor. When an act is abetted with the intention on the part of the abettor of causing a particular effect, and an act for which the abettor is liable in consequence of the abetment, causes a different effect from that intended by the abettor, the abettor is liable for the effect caused, in some manner on to the same extent, as if he had abetted the act with the intention of causing that effect, provided he knew that the act abetted was likely to cause that effect. Illustration. A instigates B to cause grievous hurt to ZB, in consequence of the instigation. Causes grievous hurt to ZZ dies in consequence. Here, if he knew that the grievous hurt abetted was likely to cause death, he is liable to be punished with the punishment provided for murder. 54. Abettor present when offense is committed. Whenever any person who is absent would be liable to be punished as an abettor is present when the act or offense for which he would be punishable in consequence of the abetment is committed, he shall be deemed to have committed such act or offense. 55. Abetment of offense punishable with death or imprisonment for life. Whoever abets the commission of an offense punishable with death or imprisonment for life, shall, if that offense be not committed in consequence of the abetment, and no express provision is made under this Sanhita for the punishment of such abetment, be punished with imprisonment of either description for a term which may extend to 7 years, and shall also be liable to fine, and if any act for which the abettor is liable in consequence of the abetment, and which causes hurt to any person, is done, the abettor shall be liable to imprisonment of either description for a term which may extend to 14 years, and shall also be liable to fine. Illustration. A instigates B to murder Z. The offense is not committed. If B had murdered Z, he would have been subject to the punishment of death or imprisonment for life. Therefore, A is liable to imprisonment for a term which may extend to 7 years and also to a fine, and if any hurt be done to Z in consequence of the abetment, he will be liable to imprisonment for a term which may extend to 14 years, and to fine. 56. Abetment of offence punishable with imprisonment. Whoever abets an offence punishable with imprisonment shall, if that offence be not committed in consequence of the abetment, and no express provision is made under this Sanhita for the punishment of such abetment, be punished with imprisonment of any description provided for that offence for a term which may extend to 1/4 part of the longest term provided for that offence, or with such fine as is provided for that offence, or with both, and if the abettor or the person abetted is a public servant, whose duty it is to prevent the commission of such offence, the abettor shall be punished with imprisonment of any description provided for that offence, for a term which may extend to 1/2 of the longest term provided for that offence, or with such fine as is provided for the offence, or with both. Illustrations. A instigates B to give false evidence. Here, if B does not give false evidence, A has nevertheless committed the offence defined in this section, and is punishable accordingly. B. A police officer, whose duty it is to prevent robbery, abets the commission of robbery. Here, though the robbery be not committed, A is liable to 1/2 of the longest term of imprisonment provided for that offence, and also to fine. C. B abets the commission of a robbery by a police officer, whose duty it is to prevent that offence. Here, though the robbery be not committed, B is liable to 1/2 of the longest term of imprisonment provided for the offence of robbery, and also to fine. 57. Abetting commission of offence by public or by more than 10 persons. Whoever abets the commission of an offence by the public generally or by any number or class of persons exceeding 10 shall be punished with imprisonment of either description for a term which may extend to 7 years and with fine. Illustration. A fixes in a public place a placard instigating a sect consisting of more than 10 members to meet at a certain time and place, for the purpose of attacking the members of an adverse sect, while engaged in a procession. A has committed the offence defined in this section. 58. Concealing design to commit offence punishable with death or imprisonment for life. Whoever intending to facilitate or knowing it to be likely that he will thereby facilitate the commission of an offence punishable with death or imprisonment for life, voluntarily conceals by any act or omission, or by the use of encryption, or any other information hiding tool, the existence of a design to commit such offence or makes any representation which he knows to be false respecting such design shall, if that offence be committed, be punished with imprisonment of either description for a term which may extend to 7 years, or b. if the offence be not committed, with imprisonment of either description, for a term which may extend to 3 years, and shall also be liable to fine. Illustration. A. Knowing that dacoity is about to be committed at B, falsely informs the magistrate that a dacoity is about to be committed at C, a place in an opposite direction, and thereby misleads the magistrate with intent to facilitate the commission of the offense. The dacoity is committed at B in pursuance of the design. A is punishable under this section. 59. Public servant concealing design to commit offense which it is his duty to prevent. Whoever, being a public servant, intending to facilitate or knowing it to be likely that he will thereby facilitate the commission of an offense which it is his duty as such public servant to prevent, voluntarily conceals, by any act or omission or by the use of encryption or any other information hiding tool, the existence of a design to commit such offense, or makes any representation which he knows to be false respecting such design shall, if the offense be committed, be punished with imprisonment of any description provided for the offense, for a term which may extend to 1/2 of the longest term of such imprisonment, or with such fine as is provided for that offense, or with both, or b. If the offense be punishable with death or imprisonment for life, with imprisonment of either description for a term which may extend to 10 years. Or c. If the offense be not committed, shall be punished with imprisonment of any description provided for the offense for a term which may extend to 1/4 part of the longest term of such imprisonment or with such fine as is provided for the offense, or with both. Illustration. A. An officer of police, being legally bound to give information of all designs to commit robbery which may come to his knowledge, and knowing that B. designs to commit robbery, omits to give such information, with intent to so facilitate the commission of that offense. Hearer has by an illegal omission concealed the existence of B's design, and is liable to punishment according to the provision of this section. 60. Concealing design to commit offense punishable with imprisonment. Whoever, intending to facilitate or knowing it to be likely that he will thereby facilitate the commission of an offense punishable with imprisonment, voluntarily conceals, by any act or illegal omission, the existence of a design to commit such offense, or makes any representation which he knows to be false respecting such design shall, if the offense be committed, be punished with imprisonment of the description provided for the offense, for a term which may extend to 1/4, and b. If the offense be not committed, to 1/8 of the longest term of such imprisonment, or with such fine as is provided for the offense, or with both. Of criminal conspiracy. 61. Criminal conspiracy. 1. When two or more persons agree with the common object to do, or cause to be done, an illegal act, or b. an act which is not illegal by illegal means, such an agreement is designated a criminal conspiracy. provided that no agreement except an agreement to commit an offence shall amount to a criminal conspiracy unless some act besides the agreement is done by one or more parties to such agreement in pursuance thereof. Explanation. It is immaterial whether the illegal act is the ultimate object of such agreement, or is merely incidental to that object. 2. Whoever is a party to a criminal conspiracy, to commit an offence punishable with death, imprisonment for life or rigorous imprisonment for a term of 2 years or upwards, shall, where no express provision is made in this Sanhita for the punishment of such a conspiracy, be punished in the same manner as if he had abetted such offence. b. Other than a criminal conspiracy to commit an offence punishable as aforesaid shall be punished with imprisonment of either description for a term not exceeding 6 months, or with fine or with both. Of attempt. 62. Punishment for attempting to commit offences punishable with imprisonment for life or other imprisonment. Whoever attempts to commit an offence punishable by this Sanhita with imprisonment for life or imprisonment, or to cause such an offence to be committed, and in such attempt does any act towards the commission of the offence, shall, where no express provision is made by this Sanhita for the punishment of such attempt, be punished with imprisonment of any description provided for the offence, for a term which may extend to 1/2 of the imprisonment for life or, as the case may be, 1/2 of the longest term of imprisonment provided for that offence, or with such fine as is provided for the offence, or with both. Illustrations. A makes an attempt to steal some jewels by breaking open a box, and finds, after so opening the box, that there is no jewel in it. He has done an act towards the commission of theft, and therefore is guilty under this section. B. A makes an attempt to pick the pocket of Z by thrusting his hand into Z's pocket. A fails in the attempt in consequence of Z's having nothing in his pocket. A is guilty under this section.